Good evening, everyone, and welcome to the final installment of Operation Safe Spaces Family Law Seminar. This evening, Attorney-at-Law Lana Edwards-Francis will be taking us through tonight's module, Barbadian Case Studies in Family Law Matters. I don't think I need to take up any time this evening with housekeeping notes, as we're all pros at this by now. But I would like to take a minute to thank each and every one of you for attending the Family Law Seminar and for your commitment to continuous professional development. I really do hope that you found our seminar informative and that you will take a lot of the information away and find it useful in the matters that you deal with regarding family law. I won't take up any more of your time, so let's get started. Lana, over to you.
Hi, good evening to everyone. First, let me express thanks to Marcia and Robin and indeed the entire network of Operation Safe Space for seeing it fit to host this family law seminar, which I believe is twofold in its purpose. It is not only to educate, but to get us who are advocates to agitate and to be better advocates, placing pressure on the powers at B, not only as it relates to the theory, but the enforcing of the legislation. Let me state up front, this is not a lecture, and I cannot adequately go through all family law matters within the 1.5 hour limit. But however, I will seek to share with you cases based on the welfare principles. From this session, my understanding is it is with a hope that I will be able to assist you with the gathering of information, your evidence, and the outlay or the output of the evidence in family law matters, also how you will treat with your family law clients in seeking to ascertain the evidence, which is very much needed in matters, especially where there is abuse or there are circumstances which are worrisome. It all comes down to your evidence, whether it be by affidavit, whether it be oral. Family law matters, they are based on the evidence, and it is the evidence that you will use in helping to reach a decision as it relates to the application of the law in the matter. I keep saying not everyone is more or less cut out for family law. People don't see the depths of it, and sometimes we play very straight, but it is not as straight as you might think when it might be repetitive as we speak about the welfare principles and what is paramount or in the best interest of the child, but nevertheless, it is not straight. I know you would have dealt with the welfare principles in Model 6 of the program, and you're keenly aware of the sections in our Family Law Act, sections 40 to 44. You can look at sections 8 in the Minors Act, and then also in the Maintenance Act, where you will see how the courts are to deal or to treat with matters as it relates to custody, maintenance, and access. We also recently had the amendment to our Domestic Violence Protection Orders Act, which really was amended to be more inclusive and expansive as it includes the rights of the children, protection. Under the amendment, there's a widening, we all know, of the net with respect to the applications being brought before the court, insofar as extending the classes of persons who are considered to be victims of domestic abuse to including but not limited to children, in addition to the classes of persons who may intervene in applications before the court on behalf of victims of domestic violence. What is of note is that the Royal Barbados Police Force has been given some more power with their ability to issue the emergency protection orders or even to execute warrants for arrest, but only in cases where a warrant for arrest has been attached to the protection order. One may ask in circumstances where we're having an increase in domestic violence cases, why is it that not every protection order carries a warrant for arrest? That would be my personal take, that it should, but it isn't. And we are not going to spend time really debating why or why it shouldn't be. But I believe if we're looking to have the act as a deterrent or that persons are held accountable, then I suspect, my belief is that we should have that warrant attached to everything. In any event, recently I just had a case where protection order, there's also an order from the High Court for the person to vacate. And in the process of vacating there, the person was removing the blocks from under the bottom of the matrimonial home, obviously interfering with the stability. And when the party called the police to say, well, I do have a protection order, the question was, do you have a warrant for arrest attached to the order? Of course, they didn't. And they said, well, we can't help you. You need to go through and file an application and all that for breach and have it heard. But that is not my purpose here. It's just to get us to think, yes, we have an expansion of our act, but in reality, is it really meeting the purpose for which it has been expanded? Now, let me move back to our topic, which is we're trying to have a look at our welfare principles and our courts treat with them. We're going to look at some Barbadian cases. I just want you to picture in your mind, when we think about the welfare principles and family law matters, who are the players in the family law matters? Just think about it for about a few seconds. Who are the players? If I was to ask you, you would say it's obviously the parties, some would say the attorneys, the social agencies, the judiciary, and you are all correct because several parties, several persons make up the players in family law matters. We are all aware, or we should be, of that whether in matrimonial proceedings under the Family Law Act or custody proceedings under the Maintenance Act or the Minors Act, or even under the Domestic Violence Protection Orders Act, where an order has not been made either under the Family Law Act or the Minors Act, a magistrate can make an interim order for custody of a child once it has been brought before the magistrate. And we're all aware that decisions with respect to children ought to be in the best interest, That is paramount. It is not the only, but it is the paramount principle as we look at the best interest. I'm going to go right in and we're going to look at a case which was decided in 2018. It first came on in the High Court in about 2015 before Justice Richards, but there were a considerable amount of interlocutory applications, one being the right of parties to the contemporaneous notes of the welfare officer, the person who conducted the interviews. Normally we know and we're aware that we get reports, but a question arose in a case where they were looking at the care and control of a minor son, and the court it was a boy, and the claimant in this case was a gentleman, and it's the case, I'm not going to call the name of the case, but we refer to it as W and J. And it was an interesting case because it went all the way up to Court of Appeal on whether parties would have been entitled to the contemporaneous notes, the interviews, and it actually went further in the Court of Appeal. It went to the CCJ. The judge at first instance, Justice Richards, made a ruling that yes, parties could apply for and be allowed access to those contemporaneous notes outside of the report. Then it was appealed. The Court of Appeal said no, but then the CCJ came back. But again, I digress. But that is just for your knowledge. You can check out that case if you do find yourself in those situations that you require these notes. As I said, this is a case where the claimant, the father, is claiming care and control, and the mother, the defendant, is opposed. And the court's position is, Justice Richards, the evidence. It is for this court to determine what is the paramount or best interest of the minor child. To this end, the court took into consideration the oral and affidavit evidence of the claimant, his sister, and the defendant. And here, this is where I keep saying evidence in family law matters. It's very important how we present the evidence before the court. We have to lay all out. The court also considered the oral evidence, the reports and the notes of the officers, the evidence and the report of a counseling psychologist who provided counseling services to the minor child at the request of the claimant. With regard to the evidence of the officer, the court is satisfied that the defendant did not establish that there were significant errors in the notes taken by the officer. So even though they would have won for to have access to these notes, the fact is the notes did not really help their case because they did not establish that there were significant errors. The defendant alleged the officer did not accurately take notes of what was said to her by the officer. However, the court finds that the officer's notes represent an honest, credible representation of what was told by the defendant and other persons. Again, how we present. We know and well aware that we are not psychologists, we're attorneys. We need the help and the assistance of the social powers, the powers at B, to be able to provide independent reports on matters. However, this is not to say that you are supposed to take every report as the gospel, but you have to be able to assess the report objectively and based on your interviews with your clients in the matters, because the truth is, you have to, normally in family matters, it is not as simple as somebody just coming in if it's a breach of contract and just saying. Normally with family matters, you have to spend a little more time, ask a lot more questions, prod a little more, may have to do more than one interview to be able to get the evidence, to be able to get the facts and the circumstances, especially where there is abuse. In any event, we would all know that anytime there's acrimony between parties, the children will be affected by it, whether there is physical abuse. As long as there's acrimony, children will be affected. And the court looks at this in this decision, in this matter. The court notes that the minor child is conflicted and negatively impacted by the acrimony existing between his parents. Their affidavits were characterized by allegations and counter-allegations. But at the end of the day, in an effort to discern the truth of the matter, the court relied heavily on the evidence and the reports of the officer. So that should give an idea of how much weight the court places on these independent parties who have been trained to investigate. Not saying again that, because as we know, we are human and sometimes biases may appear based on personalities. The person who's able to smooth talk might be able to convince one way or another. But at the end of the day, we still have the duty to put the evidence out there as it relates. What was of concern in this matter, and it's stated in the judgment, it is the opinion of this court that the defendant has not responded satisfactorily or convincingly to issues raised in the report. If there are issues, you are allowed the opportunity to respond and respond convincingly. Excuse me. The background of this case is one where there was a lot of acrimony. I think at one point the mother was accused of, who's the defendant, was accused of beating the child unmercifully. And there was also allegations of the mother grabbing a cutlass. A cutlass was involved and all that. And the mother's thing was, oh, she didn't intend to hurt the child. She was seeking to protect herself. Of course, this child at this time was about 15 or 16 years old. So we're trying to work out, the court is trying to work out, protect yourself against whom. It is stated in the decision, the court had areas of concern. The court finds that the mother took a cutlass from her car in the sight of the minor child who had just been lashed and asked to sit outside the home as a punishment for his rudeness. Certainly something is up there. It is not an everyday normal occurrence. And then there was the issue of the child not being allowed to pursue extracurricular activities, the mother interfering with the child, extra lessons. Another area of concern in this matter was that the mother's partner had admitted to being engaged in illegal activity. They were smoking. So you can get a picture of what is happening in this case. And we talk about the welfare principles and what is in the best interest. And yes, we know that access, it is not a right of a parent, but actually that is a right of a child to have a relationship. But of course, that has to be balanced. What we will look at is what the court stated in respect to the welfare principles, the court, and that is where we want to get to, how the court treated with the whole issue of the welfare principles and how the law is viewed in these matters. The court says the central issue for the court's determination is whether care and control should be granted to the claimant. And they quote Section 8 of the Minors Act, which says, where in any proceedings before the court, the custody or upbringing of a minor is in question, the court in deciding that question shall regard the welfare of the minor as the first and paramount consideration. The law is crystal clear that the court must regard the minor's welfare as its first and paramount consideration. That welfare is not the only consideration, I would have said that before, but it is the primary consideration. And it is for the court then to determine what is in the paramount or best interest of the minor child. And the only way the court can determine that is based on what has been placed before it, whether evidence or, as I said, reports, independent reports from the powers at be. Let me stick a plug to say, drawing from a case I recently had where a parent was, in essence, blocking another parent from having access to their child. It was a case where the father had somehow tricked the mother, who was not a Barbadian, into believing that he was granted care and control by the immigration. All he was doing was to apply for citizenship. Long story short, the mother moved to Barbados because she could not stand to be away from the child. What happened was, when she approached immigration and she found out that this gentleman was really not saying the truth and that immigration had no right to grant anybody care and control, she sought legal representation, and I would have filed an application before the court for her. At this time, the child would have been about 12 years old when the application. What was interesting is that the mother had serious concerns. She had serious concerns because the child was a girl child. The father had allegations of rape, not one, but twice. He was before the law courts charged, and she was concerned about the living arrangements. There was no bedroom door. There were all sorts of stuff. But what was of concern was that an independent report was ordered. And at this time, he had moved out of the house where there was no door to the bedroom. And he was now living with the girlfriend. The girlfriend was living in a two-bedroom house, two-bedroom, with 4 other persons. It was a mother, a brother who was about 18 years old, the girlfriend, and then he. And he was arguing that the child should have access now to this child. He should be allowed to keep this child, and that he was prepared to put a separate bed in the bedroom with him and his girlfriend. And the question remains, should a 12, 13-year-old be sleeping in the same bedroom as an adult male and his girlfriend? And a report came back to say, yeah, once he has the same bed, but it triggered something, and things have to trigger. You have to be triggered. This is a 13-year-old girl, and these are young parents. And I remember I raised the issue and fought very hard for this not to happen. And Justice Richards was the judge at the time, and she agreed that she needed a further report and needed less cross-examine the officer in this, because the evidence really was not measuring up with the report as should be. Long story short, we did not get to the point where we would have been able to cross-examine the officer on it. He was subsequently convicted on the charge for rape. So that put a natural end to the proceedings. But what was later learned was that because of his personality, and you knew it, he had the ability to be able to catch you up in the web. So as attorneys at law, and especially in family law matters, we have an obligation to be able to see beyond the flowery words, what I call it, and the personality. My client was very reserved, and she was a quiet, and almost as if you can run over her, but he was more out there and engaging. So it went, and he would say things that whatever you want to hear, is almost as though you have the proper words. But we have to realize what is in the best interest and what ought to be, and you have to balance that. And the only way is if the evidence is out there. I mean, it has to be this family law. It is based. You have to get it out there, and you have to be able to put your case before the court. What you think might be or might not be so important, you have to be able to assess and to really do justice for your clients. In any event, the court in this matter agreed that the the defendant in this matter, the mother, really was not to have care and control. There were too many question marks in respect to the violence and the activities there were that were not in the best interest. Why would you not want your child to be a part of an extra or even to get lessons? Why are you blocking the process of developing a healthy child and a child which the report said has already been affected by all the acrimony? And hence, the father was granted the day-to-day care and control in this matter. At that time, however, the child was 16, and if you're aware of the Family Law Act, Section 43, a child at that age, 16 years old, really has a say in respect to who will they prefer to live with. And at that point, and for access, the court had reserved its right to hear further arguments with respect to access, given the age of the child and all that. Unfortunately, like many matters in family law, there is not a recorded decision on that matter, or even if it went further. So we don't really get what happened to the access, but at least we have an idea of where the courts are looking in terms of the paramount interest of the child. If we go further, in the said decision, the court would have referred to a matter that was adjudicated by Justice Reefer. And the court felt in our previous case that this matter with Justice Reefer really brought down how the courts view the welfare principles as it relates to the best interests of a child, and that being the paramount consideration. And this is a case which would have been decided sometime in 2011. It first came on for hearing in 2011. Then the parties in this matter is interesting. This is a case where, like many matters, the parties come to an agreement with day-to-day care and control and access and maintenance and all that. But then circumstances changed in 2014. By 2014, the mother, who was the claimant, who had the day-to-day care and control of the children, and this is a case of W versus W. I prefer not to call the names, but for those who might have access to me and you wish for me to forward, or I can send them, I could always send copies of them to you so you can have a look at the cases. I can always send it to Robin and she can disseminate if she so desires. But this case of W versus W, it's an interesting matter because, as I said, the parties had already agreed on the day-to-day care and control. They had agreed to the access, they had agreed to the maintenance, everything. But in 2014, the wife got married, and she got married to a Canadian citizen. She's living in Barbados. The father of the children, the defendant, is also resident in Barbados. But what happens is she takes a severance package from work and she's in Barbados. She's married to a Canadian and she's made plans to relocate. So there are 2 children. She's made plans to relocate. And obviously the father is of the opinion that this is not in the best interest. And he's lists several things. She's relocating, she's not going to a job, she's going to do further studies, even though the husband says he will support the children. There's no evidence that he will. People can say what. And of course, that is how the matter went between the parties. There was great conflict. But I believe Justice Rifa did an excellent job in terms of really looking at the welfare principles in terms of what is in the best interest. What is to note though, again, in the affidavit evidence, the applicant stated all the benefits, why it was in the child's best interest to move and to be the children's best interest to relocate. And I mean, everything was set out. Again, the court had some difficulty with the defendant's evidence because even though he was opposed to these children being relocated, he really did not put forth a proposal of how best he could care for them. He was living between two homes or three, yes, between a sister and a mother. He had one bedroom in their house. There are two children, so obviously they'd have to, all he was saying is he was prepared to look after these children, but he was not saying to the court how best he was prepared to look after these children. The matter came on for hearing, and the objection was she didn't have a residency. The children would now have to go to school. They'd have to pay for education. Free education was in Barbados, and that it would be difficult for the children to adjust. Additionally, that his obligation to pay maintenance would be increased because obviously of the rate and all that. But the court, and what we're going to focus on, is the law in this matter, which I think it gives us a sense of how the court views these matters. The statutory principle applicable to these circumstances, generally issues of custody, is so well known as to have become trite law. That is the welfare of the child being the first and paramount consideration. And yes, because it seems so simple and so repetitive, people might just push it aside. Justice Rifa goes on to talk about Section 43(1) of the Family Law Act. In proceedings in respect of the guardianship or custody of or access to children of a marriage or union, the court shall regard the welfare of the children as the first and paramount consideration. The court may, subject to paragraph A, make such order in respect of these matters if it thinks fit. It goes on to say, Section 8 of the Minors Act, there is seemingly simple concept that is profoundly difficult in its application. I repeat that. This is a seemingly simple concept that is profoundly difficult in its application. It involves consideration of the rights of the child, of which the best interest, welfare of the child, feature prominently, and the rights of the parents, accepting, of course, that the welfare of the child trumps any right of the parent. It involves consideration of the rights of the child, of which the best interest, welfare of the child feature prominently, and the rights of the parents, accepting, of course, that the welfare of the child trumps any right of the parent. In fact, the language of the courts has been re-engineered to avoid any reference to rights of the parent and express in terms of the rights of children to have access to their parents. As I said before, access is a right of children and not necessarily that of parents. And it can be a very difficult concept for parents to be able to grasp or even come to grips with that. So then it is our duty to be able to guide our clients along along those lines. It is interesting, if I may say, that I also had a matter, and this was a young girl, she married when she was just about 19 years old. And at that time, she married an older gentleman. He was in his 40s. Not much education. She was just she just enrolled back in university after like the second year of marriage. But what transpired was they had children together, and there was a breakdown in the relationship. It didn't last as long as she would have imagined. And because she was young and the father believed that he was the one in the proper job and he knew what was best for the children, he literally put her out with no access to the children. Excuse me. Every time she would seek to have access, it would be some excuse or another. At one point, he did allow her to see the children at her mother's house. And then for a few hours, and by the time the children got back, he claimed there was a rash and the environment was not the best. She begged, she pleaded, and he then eventually allowed her to see them again, but he had to be there. He wanted to be there so that she could not hold the children. He was right there standing up over her. No, there is no evidence that she has abused the children. All that he has is a fear that the rash on the child is as a result of something in the environment at the mother's home, which really made no sense because at this time it was around summer anyway, eczema flares or whatever. But I'm saying that to say he believed he had all rights to these children, and she had none. An application was filed before the court, and an urgent application, and in fact she was granted access to the children. And he could not conceptualize, he could not come to grips that the children should have access. I mean, she was asking for the children to be returned to her care, but the court, because it was an urgent application, it was allowing him to be able to put in his evidence, because she'd put in all of hers, well, to that point, allowed her access. And even with the order, he was diabolically opposed to her seeing these children having, and that cannot be in the best interest of a child where there is no threat, no imminent danger to the life, limb, or liberty of any child. He is in fact, or he was in fact at that time, infringing on the children's right to be able to enjoy a relationship with their mother, and that ought not to be. And we will, as we go further in, we will see that the court, even in cases where persons have not acted in the best interest of children, are still allowed access, because there's a belief that children ought to be able to bond with their parents. It's the belief, and it's a school of thought, that it can only be to the betterment of a child, unless, of course, there's the evidence of, as I said, abuse. And even in those circumstances, the court will allow for some measure of supervised access. But as we go back to Justice Reefer and her decision, She says the statutory concepts of the rights of a child reflects a well-known principle long enunciated by the English courts in equity. Historically at common law, the issue was one of superior legal rights, and the father was in law vested with those superior legal rights and entitled to the legal custody of all legitimate children, in which the courts of chancery exercise a paternal jurisdiction, and we know the Latin term as parens patriae, of an infant. As parens patriae, which is what the court took on, equity for issues of rights in favor of considerations of the welfare of the child. And we will know that there are, in some cases, even with the death of one parent, where there's been no, there's death of a parent, they're separated from the other parent, and at the death of one parent, the court can intervene on applications and allow someone who is not the biological parent to take on the role of the care and control of the child if it is indeed in the best interest of that child. So the court will even go beyond your natural right as a father or a mother in the instance where one party has died to allow another party, once they are in the best, it has been viewed as being in the best interest. And we do have case law with respect to that, a 1991 decision, which would have been made at that time by William C.J., where there was a father who he and the mother separated, divorced, the mother died, the grandparents were already assisting with the care of the children when the mother was ill. The moment the mother dies, the father decided he wanted the children, but there were questions as to abuse, there were allegations on how he treats with the children. And at one point it got so bad, there are two children. He went and he removed the daughter. He removed the daughter from the grandparents' home, which forced the grandparents to file an urgent application, And the court at that time granted the grandparents the custody and the care and control of those children. And in the decision, they talked about the crown as parens patriae, the court's jurisdiction in respect of wards of the court. And that was the first application. They were made wards of the court. And we all know, once you make an application for a child to be made a ward of the court, the moment the application is filed, the children automatically become wards. But the court said the crown as parens patriae. The court's jurisdiction in respect of wards of court emanates from the Chancery Court, so it's again reinforcing this. Inherent jurisdiction in relation to infants. It is sufficient for practical purposes to regard the jurisdiction as originating from the right of the crown as parens patriae over the person and property of infants who were unable to take care of themselves. The jurisdiction in respect of wards of court is parental and administrative, and the disposal of controversial questions is an incident only in the jurisdiction. The powers of the court extend to custody, access, care, and control. If, however, there's a parent or guardian able to act on an infant being made a ward, this parent or guardian will become subject to the orders and control of the court precisely in the same way as an officer, so that the court is the head parent and you follow your directions or you take your directions, and it supersedes even the right of the biological parent in the matter. And there may be circumstances where you have to do that, where you have to apply based on what is happening in the family situation. In any event, I will go further in the decision of Justice Refer as we're going down, and as she spoke about the rights of the child, even above that of the parent. In this judgment, she refers to a case J versus C, and where it is stated, it seems that they must mean more than that the child's welfare is to be treated as the top item in a list of items relevant to the matter in question. I think they connote a process whereby when all the relevant facts, relationships, claims, and wishes of parents, the risks, choices, and other circumstances are taken into account and weighed. The course to be followed will be that which is most in the interest of the child's welfare. So you take everything and you weigh when you looked at all the facts, the relationships, the claims, the wishes of the parents, the risks, the choices, and other circumstances. When you weigh that, the course to be followed will be that which is most in the interest of the child's welfare. That is of first consideration because it is of first importance, and the paramount consideration because it rules upon and determines the course to be followed. The dominant matter for the consideration of the court is the welfare of the child, but the welfare of the child is not to be measured by money only, nor by physical comfort only. The word welfare must be taken in its widest sense. The moral and religious welfare of the child must be considered as well as its physical well-being. Nor can the ties of affection be disregarded. And then, right. And then Justice Rifa asks yourself the question, how does a court determine what is in the best interest of the particular child or children? And what considerations does it take into account in making this determination? And case law reveals that in making this determination, the court pays regard to the physical, the mental, material, moral, social, educational, medical, and religious well-being of the child. There are several miscellaneous considerations often taken into account where relevant. For example, the wishes of a child old enough to be considered. And as I stated, we know that our legislation, Section 43, speaks about children aged 16 years or so. Additionally, the conduct of the parents generally and specifically towards each other and the child is also looked at. Maintenance of the family unit, material standards and advantages which the child reasonably expects. Additionally, preserving the status quo in the child's life, the happiness of the child, the position or attitude of new partners towards the minor child. All these things are looked at. And again, the court can only be made aware of such if it is laid out before it. These considerations are by no means exhaustive, as each case has a particular set of facts and circumstances to be evaluated by the court. How then was the court in a position to evaluate sets of facts and circumstances if we fail to place them before the court? The importance of determining each case on its own facts and avoiding an approach that draws assumptions from given facts cannot be stressed enough. Each case has to be determined on its own facts. And though cases may be similar, there are no two cases alike, because each family brings with it its own idiosyncrasies, its own way of doing things, its own challenges. And hence, you cannot brush all family law matters with the same brush. And we go down. Give me 1 second. All right. It is noted, and this is noted in her case, that at no time has the parenting abilities of either party been seriously put in issue, save and except for the half-hearted reference to the respondent's stress and anxiety. Think about it. And it's amazing that all these family matters, when decisions are being made, there is always some reference to the evidence not being placed before the court to back up the position of the party, whether it be the applicant or the defendant or the respondent in the matter. If there are issues with respect to concerns as to the parent's ability, not just preferences, I prefer the child to wear pink or you prefer the child to wear green or yellow, but I mean serious issues, then they ought to be placed before the court. There are times, even with religious beliefs of one parent, that those religious beliefs may in fact be of detriment to a child, and you must raise it before the court. I've had a case where the mother had gone into a new relationship and was in occultic practices, and the child was being exposed to pornography, and she was going to school and drawing those images. Now, in those circumstances, question marks would have to be raised whether this is a home that this child should be allowed to be raised in. It alerted teachers, they wrote to the father about it. They were concerned about the drawings that the child, and on investigation, it was learned that the child had now gone into a new religion, and these things were part of the religion. So you cannot take things at face value. We would appreciate that both parents should want what is best for minor children, but even in wanting that, we as human beings can be very selfish in the way we do things, and we want to do it how we prefer to do it, and it might not necessarily be in the best interest of the child. It is coming up to 6:30. I know I've been talking at least for an hour. I can break here right now for a short, 5 minutes. Is that okay, Robin?
Yep, that's perfect. So let's come back at 6:35. And I also just want to mention that you would have received by email a copy of a survey, just your experience with the course. And if you could take a look at that for us, we would really appreciate it. So we'll be back at 6:35.
Okay, so we can start back. So I trust that I'm not losing you, but we appreciate that the time is limited and I just want to get through a few things. I did see in the chat someone requested copies of the cases, and that's no problem. I can forward to Robin by email, and I'm sure she will disseminate accordingly. I noticed in your module on the welfare principles, there was a question about the whole issue of supervised access and circumstances in which this is facilitated. It is interesting because, again, the courts really view children having access to parents as truly a right of a child. I can't stress that enough. So that well in our natural ability, we might think or say as this cannot be the best interest. These studies have shown that children desire to have a healthy relationship with their parents. Unfortunately, due to the nature of some parents, whether it be that they have anger problems or even a mental condition, they are not able to relate to the children in a healthy way, but they would still wish to have a relationship with their children. And hence, that's why we fight for access to be supervised. Some parents feel threatened, so they don't want to be in a close because of whatever past experience they might have with a partner. So they don't want to be in close spaces with the person, so they prefer not to be in the same room. So they might choose to do open spaces, a restaurant, a park. I know in a matter that's very contentious, this is a case where the lady, she got involved. The person at that time was married, albeit the relationship came to an end, but he could not understand that the relationship had come to an end. It so happened that after saying the relationship had come to an end, she found out she was pregnant, and he had reason to come by, and she alleged that he raped her. Now, with that in mind, she's saying, but he has done this to me. I am so scared of what he will do to our daughter, in light of the fact that even after the child was born, she tried to, still bring him into the child's life, and he would do strange things. He would take off the child's pamper. I'm talking about a baby now, a child's pamper, and got her there naked and spread out and say, oh, this is okay, their ear and all that. And because of the experience of the rape, her concern was, I don't like this. This can't be normal. Why every time he comes here, he wants to take off this? The fact remains, he applied for access. I was not involved in the matter at that time, but the court did in fact grant access. But they involved the social agencies, and the recommendation at that time was that the access will not be overnight, and that it would be done before it was done with an independent party just watching. And it was a party that was chosen by the mother, just so the mother would drop the child, walk the child to the park in the presence of the party, and they would be off while he spent time. As the child got older, the child wanted the mother to come, so she would sit off, and the father could not understand why it is that I can't be in this close confine, why it has to be that I have to be in a park, why I have to meet my child. But at the end of the day, I heard Justice Chandler says, you cannot ignore a person's fear. and treat it lightly. There will come a point in time as the child gets older that they will get access, because there's not any evidence now to suggest that he's done X, Y to the child. But for the time being, the court is not going to just stop access out of your fear. Even in cases where parents have done very bad things, terrible things. In fact, there's a decision that came out in 2009. It was a child care board matter, and it was a case where a mother was incarcerated on 2 separate occasions for 2 violent crimes. I think one was a child or relative she had actually, I don't want to say it, but she'd actually murdered. And the child was placed in the care of the grandparent. And when obviously the mother came out, it was known that she had epilepsy and it was affecting the brain and all that. But it was also noted that when these acts were created, she was not under seizure. In any event, even though the child care board had made an application for the child to be made a ward of a court and made an application to dispense with the mother's consent and to allow the child care board to put the child up for adoption. Imagine all these applications. And right there, the mother has said, I still need to see access. And access was granted to the mother. And it was granted under the ambit or the parameters that the access would have been done by an independent party, because it was still felt that the court stated actually that the court is guided by the need to provide the child with an opportunity to establish a meaningful and enriching relationship with his mother. You can imagine. We'd be saying, but really? And it's also guided by the need to do so in an environment that will ensure that his physical and emotional well-being is not at risk. So you have to balance that need to enrich, to establish that bond between a parent and a child, and you have to balance it against the risk. So there are cases where the court, you have to be able to identify which are those cases that you're going to say, we really can't allow this mother, we shouldn't allow this parent to be, based on the circumstances and of course the independent reports, we can't allow them. There's a case I've had, we did the entire case, and today the defendant does not have any knowledge of the mother's address, and the judge made it into an order. At no time is this mother's address supposed to be disclosed. So when you are writing your reports, no mention of this address. When we're filing documents, no mention of the address. And that is how serious it is. And it was a point which was raised because this was a violent relationship. The mother had already, she'd fled the relationship. At one point, she was in a safe house. She's now coming back on her feet. And she was still very fearful because at one point, before she came to court, the father did not know where she was. And what he did, he gave the child a cell phone with the tracking device on. And because she was quick, she picked it up. And of course, the cell phone got dumped, which she came to court and said she destroyed the cell phone. But then the circumstances of why the phone was destroyed and all that. And then there was the evidence because she had an independent party who she was bouncing things off of, separate from an attorney, a person who was coaching, and she was able to share with them. And the court was of the opinion, based on the evidence and the recommendations from the social agencies, it is not in the best interest for him to know where this mother lives. And hence what she does every weekend, She meets him at a open space, lots of people, so that she feels comforted that he will not follow her or whatever. I think a couple of months ago, she thought he followed and she changed addresses. But those are things you can ask for an address not to be disclosed, so that parents can still enjoy the company of their children without the other parent feeling threatened, that they can feel a little safer. But we have to be able to identify the general need, or the genuine need, I should say, as opposed to, I just prefer that he doesn't know because of X, Y, Z. Again, it comes down to how we sit and we engage with these parties. It comes down to it, as I said before, spending a little more time. It is not, and if parties are part of the community legal services program, where you are on the panel of attorneys, you would know that more often than not, those clients who come to you, they are the ones sometimes with the greatest needs. They are the ones who need, not that you are a counselor, but you have to be able to discern. You have to be able, so that when you place their matter before the court, does it mean that when we place everything before the court that we will get the result we are looking for? Unfortunately, this is not an ideal world and things don't necessarily. But if you know that you have done all that was required of you in these situations, then you can feel a little more comfortable, even if it does not work out how you intended, because we can go to the Court of Appeal and CCJ, but you know you have done your best. And that is all that is required. It should never be a case where a judge is saying, your evidence was lackluster, you didn't fail, you're saying X, Y, Z. Because again, you play tricked. It can be that if it is lackluster, because really and truly you do not have a bona fide claim that this party is being abusive or has the potential to be, then that is okay. Do not go and falsify to make the story greater or worse than it is. If that is the case, that is the case. You can only put what is the evidence, but do not just brush off things. There are signals, there are signs, there are things that will alert you something is off here. I mean, trivial things where a man doesn't want a woman to see her child because the child has a rash. Not only the child has a rash, he has an ointment that the doctor has given him. And he's saying he can't trust the lady to apply an ointment that has on a thing, puts twice a day. That's a problem. That's a measure of control. And that's what happens sometimes in relationships where one party seeks to have a measure of control. In the matter that we looked at just before we break, that was a case where the mother wanted to take the children. And when the court looked at it, the court said, you know what, if there's nothing sinister behind this woman moving these children, if there's nothing untoward in that she is not just trying to stop you from having a relationship, but she's really going on to build a life, then there's not a problem. But you have to prove that there's something sinister or there's something untoward or that she has ulterior motives to removing the child. Recently, I came into contact with a client. She was non-national and in Barbados in a relationship for about 7 years or so. The relationship had a child. The relationship broke down. She obviously didn't have any place to go at that time, so she left the child, a daughter, in the care of the father. Now, what is interesting is that She found the place and everything, and then she went to have the child returned to her care. The father said no. She filed an application in the magistrate's court for access. That was her way. The application was filed and it was heard. And the day that the order was made, she was deported. You know why she was deported? She was deported because the father of the child reported that she was in Barbados and she had overstayed her visit, because he was adamant that this woman was not to see the child. She too, being a very resilient woman, she did until she applied and was able to have the deportation order canceled, and she was allowed to come to Barbados for a few months. And she did for a few weeks. They allowed her 3 weeks back in the island because she says she has a daughter here and all that. On that 3-week visit, the man refused to allow her. But again, not wanting to be deported again and risk not seeing your child, because she arranged for the child to come to visit her, paid for a ticket, sent it electronically, and the father refused. Has no reason. It is just a controlling spirit. Now, what is concerning is that this child is now going into puberty. She's 13. The father not saying that he's going to be abusive, but what is the problem? Why can't this woman, even if she's in Barbados for 2 months, a month, 3 weeks, see her child? What is the problem? And there will always be, if a parent is intent on another parent not having access. But we've seen how the courts have been able to say, even in situations where persons have committed crimes, the courts have made allowances for children to be able to have a relationship with their parents, even in circumstances where they might not be the best. The problem though we have, and I'm getting ready to close, so to allow you some time to be able to ask some questions and I can engage as best as I can. The problem is we have a social services network, which is overwhelmed. So we can amend our legislation, we can make it more inclusive, we can allow for all applications to be made on behalf of minors for protection orders. We can do all that, but if we do not increase the human resources of our departments, our social agencies, lawyers are not social agents. We are not. We are there to put evidence and to argue based on the law, our client's position. We are not. We recognize how the courts lean very heavily on these persons. If persons are overworked, things will start to slip through the cracks. And it is not because they don't have a keen eye or that they're not sharp or their heart is not in the right place. They are overworked and overburdened. They can only do so much and no more. So what do? We have to look at ways in which, and I'm grateful for these seminars like these, so that we can become more aware. We can become more aware and we can make it a bit easier on clients. The worst thing is for a person, especially a person who is going through emotional ordeal, to not get proper representation. That is an indictment on us as attorneys. That is an indictment on us as professionals. Because we would once again be falling into the category of those who are failing these individuals who are coming looking for legal advice. We can't give them beyond what the law allows. We can't pull things out of a hat. So what we do have, which is our ability, we've been trained to research our matters, to place our evidence properly before the court. We can do that and do that to the best of our ability. As I said, does it mean that everything will work out for us? Maybe, maybe not, but at least we would have done what is required. So it requires preparation. I love Justice Reefer for saying that sometimes because it's family law, we play trite with it and think that it doesn't have value when we talk about what's in the best interest and what's the best welfare of the, but there's so many technical issues. I believe that in that case where the mother was allowed, did the father even put up a proper, he's done something more, the court would have a little something, but it has gone to his favor? No. But they would not have the opportunity to say, but you really did not say to us, how then? This party is not, you're saying they're not fit to look after a child, then you need to prove how then are you? How fit are you to look after this said child? How is it that it's not in the best interest for this parent, but it is in the best interest of the child to be with this parent, but it is in the best interest of the child to be with you? And those are not things that you pull out of a hat. The evidence must speak for itself. It has to. Otherwise, we will continue to have things happening and reoccurring that we really are not too proud or happy about. And abuse will continue if we don't find some ways in which we can write papers. I'm thinking about it, and to advocate. There are ways that we can agitate to see some change brought to the system. It makes no sense. We've just created family courts, which is wonderful, but we have the same amount of officers. So that reports, which really should take 6 weeks, 3 months, sometimes even longer. And it is not because they don't care, they just cannot meet the workload. I think that's it for me. I'm going to shut off there because I think I've been talking a bit much. And I'm going to turn over to Robin.
Thank you, Lana. If there is anybody who has any questions, or if there are any discussion topics that you want to bring to the panel, please feel free.
Hello, good night, everybody. Lana, thank you very much for ably taking us through connecting the theory that we have been doing, if you could put it that way, to the practical in the case studies that you chose. I thought the case studies were very informative and useful. Just going right back to the beginning when we started, and I agree with you that perhaps we need to strengthen our protection orders by making sure that everyone carries an automatic arrest clause. But how long it will take us to get there. But just to say that in the section of the Act which outlines the duties of the police, there are 5 duties that are set down for the police, one of which is to ensure that there are no further breaches of the law in relation to the domestic violence matter. And so I have invoked that responsibility, that duty that the police have to make them do something. Because if somebody has a protection order and you have an individual who is removing blocks from a foundation, the police can find some way, they can find some kind of something to be able to at least bring immediate relief. Remember that the police as well they have the powers of arrest. The arrest is limited. I think it's they can't hold the person for longer than, I think it's either 24 or 48 hours. Don't remember whichever one off the top of my head. But they also have that option So I find sometimes it is the way that the PO Cap 130 is interpreted. It has a lot to do with which police officers on duty, whether he's tired, whether he won't be bothered, kind of the same thing that you were talking about with the welfare officers and that kind of thing. I mean, they are overworked, you know, police have a million other things to do, but I find that it is very subjective according to the station and so on and so forth. But I just wanted to mention those two provisions so that attorneys know that they're there, because sometimes you really have to stick on them and make sure that they do what they're supposed to do to be able to keep clients safe.
I agree with you, Marcia. I think the problem is not that it isn't in the legislation. The problem is not all police officers are trained in the legislation. And I believe that it is easier for them to say, contact your attorney at law, especially, and I could see why in this case with the block, this is a matter where every week almost she has to call the police. And I can see where they can start to say, I am tired. Do we have because they want their say, but they don't want the duty to have to get up and thing. But I think that perhaps we might need to ask, especially for those who are fielding calls, to be able to say, to be able to understand the legislation and the ambit, because it makes no sense just a few officers, especially with amendments, a few officers only knowing what their duty and role is. And so means it can be very difficult. So means you have to write letters. I've had to do that, write letters to the commissioner to be able to get something moving, understand this is what it is and how it is. Which thankfully,
I wholeheartedly agree with you.
Results do happen in those.
I wholeheartedly agree with you. There are a set of older officers who still operate off of the 1993 law. They are completely oblivious to the amendments that were made in 2016. But what I can say for the commissioner, I can vouch for what you just said. Anytime I write a letter to him or draw a matter to his attention, he always makes sure that somebody follows it through, and that means that much I can say about him.
That is true.
Yeah. The final thing I would
there's
say. Oh, sorry. Go ahead. Go ahead.
No, you go ahead, Marcia. You continue, Marcia.
It's all right. I'll give way. I just quickly wanted to say as well that complex matters of domestic violence are to be handled by the station sergeant. And that was something that Commissioner Griffith had put into place to kind of help to facilitate us during COVID, but it never stopped, right? So that case where you have to call somebody every week like that, that is really supposed to be handled by the station sergeant. And he is supposed to, if he cannot manage it, escalate. So sometimes it is also useful for us to know that these things have already been put in place and we already have that facilitation so that, again, we can invoke these things.
I see there's a question. As an attorney, am I obligated to tell a client when they are being unreasonable, and if the response is not positive, do I walk away? Now, I smile because in my years of practice, I've not had an opportunity to do such until quite recently. And this was a matter where the mother was, during the pregnancy, the child is now 9. During the pregnancy, the mother and the father had some issues. That was understood, that was agreed. He was violent, understood, agreed. The mother moved out. and had no fixed place. She was just moving. She went to mother, then mother couldn't agree. She kept moving. She left the child with the father. At that time, he was about 3 years old. He's now 9. The father enrolled him into a private school. He was in a public school before, but the father felt, he was a boy, he was being distracted. He needed that environment, smaller classes. He enrolled him into a public school, a private school. He looked after the child. He has been. The child is doing excellently according to the teachers, punctual, work, pleasant, open, whatever. The father was allowed the mother access to the child every weekend, not even every other. If she wants him every weekend, she can. He said, I was working for the mother. I prefer at this stage, because he is in a school with a particular framework, and especially in COVID, where the private schools seem to have had a better handle devices and everything. He's on a structure. I prefer that he didn't go to live with the mother. I mean, we've just filed this application, and he filed it. She had moved about 2 different addresses within 3 months. The circumstances were investigated, and the welfare report came back. The officer gave a thorough report. She was very fair to my client. She said, yes, she's a little young lady. She's not employed per se. She tempts here or there. But one thing she can say, she lives with an older son. There are no strange persons around. Sometimes the younger people, you have to question them about the persons they're allowed to get in. But at this time, she believes that the child, because of how he's adjusted, because the mother is not really in a position to support the private school and all that, and she's not in a position really to be able to look after this child. And not only as it comes down to money, she just is not, we believe she might have a little mental something going on, but not major, but she has to be coached through. Long story short, I found the report was very favorable in terms of, yes, you didn't get the child, but I could understand why. Why would you want, and especially now, why would you want to move a child? We are already disrupted in COVID. So I advised her accordingly. I said, I can see this judge is not going to be prepared to move this child based on this report. I'm not saying my personal view. I'm telling you what this report, and based on what is coming out of this report, you cannot even say the report is one-sided because it speaks favorably to you. All it is saying is that this time it is better. Well, the lady she said she would prefer if the next time I didn't appear on her behalf. We were in court the next day, if I would sit out. And I just simply went to court. I asked the court for leave to withdraw. I explained why. And the court was a bit taken because they said, well, you've put all this and whatever, but we understand the position you found yourself in. And I said, at the end of the day, I prefer to withdraw, and this is me. This is not you, this is me. I prefer to withdraw from a matter where a client is not comfortable that I am giving them what they so want, and allow them to go and find counsel to do that, than for them to walk away and say that I did not do my best for them. I don't know if you understand it, but that is it. I prefer that. Walk away and say, Miss Edwards, I prefer you to go elsewhere and find someone who can give you what you believe they can, than you walk and say, Miss Edwards did not do enough for me. And that was it. And the court understood. In fact, the court said, Ms. Edwards, I know you're not under obligation, but could you please sit in on the hearing so that for the other attorney, I want you to be very clear, this matter is coming on X date. If the young lady wants to file anything further which she thinks will move me or move the position or whatever, let the attorney know. And I said, no problem, which I did. And I sent out a full letter, and I sent out all that transpired before. Or maybe we've had some orders on that matter in my client's favor too, and all that. And I would be preferred to speak to, I don't know if she's got her new counselors yet. The matter still has a few months before it comes up, but I walked away. And there's some things you might have to. Any other questions? Any comments?
Hi, good evening.
Sorry, go ahead.
Oh, sorry, Marsha.
No, go ahead. I defer, go ahead.
No, actually, this something of concern to me. I'm going to the magistrate's court on a matter tomorrow. It is about access, but the male in the relationship is very abusive. He doesn't live with the mother anymore, but he does have a tendency of turning up every now and again. And when he's in one of his tirades, he would destroy things and throw around things and behave in an aggressive manner. And the magistrate's court didn't allow her to apply for a protection order because, sorry about that, didn't allow her to apply for protection order because she doesn't live in the same house as she does. They were living together briefly during, I think, the initial shutdown last year. And my understanding of the amendment to the act is that it would include persons such as herself who would basically have a domestic relationship. And I just find it strange that you have a lot of these people walking around who need court's protection. The police are telling them, go to the court and get a protection order. And then when they get there, they're told, no, you can't apply for one here because you don't live with the person. They go back to the police and the police send them back to the court, and it's a vicious cycle. So I must now go to court tomorrow on an application for access and explain to the magistrate that she needs to be given the opportunity to apply to make an application for a protection order. And even though there's no application for one before the court still does have an obligation to tell him that he's not supposed to physically assault her or threaten to assault her. So it is just very challenging for me.
Yes, because whilst I can understand why the magistrate says that, because visiting relationship under the amendment speaks to a relationship where the parties do not live in the same household, but in which there are romantic, intimate, or sexual relations. So I suspect that's where the magistrate is holding the position that there are not. But outside of that, outside of a protection order, I don't do criminal law, so let me just put it out there. I am sure that because you said he's breaking up stuff, that there has to be something, even if she files a formal complaint against him. A formal criminal complaint against him.
Yes, that has been tried. The problem is that she goes to the police send her back.
It's a criminal offense.
Yes, she goes to the police send her back. So they're just constantly back and forth.
She's going and complaining. She's going in there not to complain, but I've come to lay a formal complaint. I want to give a statement. Now, if she makes those comments, correct, because they're saying it, laying a complaint, and they have not taken action, then she can take it further. So you're not going to lay a formal complaint.
I have heard both magistrates and police give the explanation and interpretation that you just did, Lana. But my response is always that the act also covers a former spouse. And we have this
But
nonsense that
then
the Chief Justice did the
it's a
other day.
spouse. But then
A
it comes,
former
yes,
spouse.
it's a form you qualify as a spouse in the natural sense of the word. What is a spouse? Cohabiting together for a period of 5 years.
Yeah, but
So then I am not
in the Protection Orders Act, if you have expanded the classes of people and you have included visiting relationship, then are you telling me that the partners in a marriage or a relationship that lasts for longer than 5 years are termed as spouses, but the ones in a visiting relationship have no name?
Yeah, because the visiting relationship is that there is some measure. So you don't necessarily live in the same house, but you visit him for whatever pleasure and he's gone. So he's a partner, but you don't qualify as his spouse.
My
I
thing
think that with that
and
interpretation,
visiting can be defined separately.
But the act doesn't, and that is where the act still has some flaws.
I think it comes down to the
Remember,
law and the
magistrates
intention.
are creatures of statute. That's where you have to start. They are bound only, they don't have the inherent jurisdiction of the court behind them. They are bound by black and white and what is recorded in your act. They're
But that
creatures of
makes
statute.
the Chief Justice's interpretation the other day to limit its scope even ludicrous, because if you have two parties to a marriage, then if as long as you're divorced, that's your former spouse. Like that's what it is. That's your ex-husband until you die, or your ex-wife until you die. So then his interpretation to limit former spouse, if you are only restricting it to individuals who have been in a relationship for 5 years or more or married, certainly does not make sense. But in the explanatory notes to 130A, if one of the intentions of the act is to expand the class of people covered under the act, then to my mind, and like you said, you're right, it probably is a legal flaw, but it's one that we need to fix. How can we still only interpret spouses then in a way that excludes visiting relationship?
Has to be dealt with. Has to be. I dread the magistrate's court these days anyway. Now, that's just me personally with these types of matters. And in fact, I've recently asked not to. I don't do any magistrate court matters. But that's just personal. I find that they can be a bit draining. A bit draining. Let me deal with the High Court and where I can put all my evidence on paper, and let's argue. Let's deal with it on that and go.
I totally agree, and I think that is also advice that attorneys need to give to clients, especially when relationships are characterized by domestic violence. These matters really have no place in magistrate court. They need to be taken directly to the High Court because of the complexity and because
it would come under, because for the Family Law Act, you have the Section 91, which is the injunction where we can get persons, removed from a home or cease to engage in behaviors and all of that. And that applies to persons union other than marriage or marriage. The question now would relate to which sphere or which legislation you would fall under, because right now that is what the Protection Orders Act does in the magistrate court. So again, those classes of persons are still on the outside, either way. But agree, as Rita said, and as I said, that is a criminal matter. But as I think it's Raquel that says, they cry and plead when the men are arrested, because the truth, they want something done, but they don't want to that level or extent. And for various reasons, people might think they love them. I don't necessarily think is love, but there's also a fear because they're not being locked up for any extended period of time. You breach a protection order, you get a year and 9 months. So I mean, I of course I did a matter with that. Where the guy literally broke into the house, put a knife to the throat. We went to court, and yes, he was found guilty of the breach, and he spent 9 months. But my thing is, my client was concerned what happens after the 9 months.
And also the clients very often are considering the interest of the child, and they basically do not want their child to have a quote unquote jailbird as a father. The stigma, the children are terrified, the children don't want that. They don't want to deal with the fallout socially from that. And yeah, there's a big fear of what is going to happen after. So you have these conversations with clients all the time, and they say they don't want to go that route, and you try to plead with them, you tell them it, but they don't want to go that route at all. And sometimes it makes you really frustrated, but you have to take into consideration that it's a big step to have this person arrested with whom you've had an intimate relationship and everything that goes along with that. So while the criminal code is there and you can ask for it, and sometimes the policemen are actually very willing to consider going under like assault and destruction of property and criminal damage and whatever, but it's a very difficult decision. And I think that is why the domestic violence protection order was crafted in the first place, because of this difficulty that still exists.
Yeah, I agree. And it has come a long way, but it still has flaws.
Yeah, the visiting relationship is definitely a flaw, and I am one that I prefer the High Court as well on the Minors Act, maintenance, the Section 91. I just try to keep away from the magistrate's court as much as possible. So I'm like you in that aspect.
Any other questions, queries, concerns? We have just about 5 to 6 minutes. It is a big step to end up dead too, I'm saying. And let me tell you, it is, it can be very traumatic, not only for the clients, but for those parties who were involved in cases where people die. I've had that. I've had to struggle with that. But at the end of the day, when we look back, because my client and I we have maintained a relationship in terms of friendship. Because you know what, when she looks back and she looked over her documents and everything, she can say, but Ms. Edwards, you did everything. She's comfortable. And that's what I talk about, giving your best representation so that if things go south, you don't have to live in the guilt. You don't have to live in the guilt. And I mean, it was a case where the father did not want the mother to have access, and he chose rather to commit suicide and take the children with him. And, just only because she was granted a temporary order for access until further hearing of the matter. And I don't even think it was so much the access, but it was when I asked for an independent report. We wanted to go in the house because the mother was not allowed to go in and to investigate the living circumstances. He could not handle that there was going to be some independent person, because again, they believe that the flowery language and the ability to make money and to be dominant and in control would have been enough to sway the court. And the truth is, it's very difficult, but life is more important. And when we look at it, is there anything we could know? Because she had a right to access her children. And there was no reason other than she was younger than you and didn't have a job. She had great family support though. But today we're wiser for it. But at the end of the day, when I take up that file, and I actually took it up again last night, even as I was looking at this presentation, I said to her, can I share your story? Can I share your matter? And she said, yes. I said, I won't call your names. And she said, yes. And because she was in my office today, I missed her, but because she recognized, she says, Miss Edwards, I know you did what you were supposed to do. When I look back, I look at my affidavits and said, did we convey to the court enough that this man had the propensity, but the court at that time would have only seen a man who did not want to give access, but these things were there. He would go to the nursery quick. The aunties at the nurseries got close to her and would allow her to come in to see the children, and he got wind. So he started staggering the times he would pick up to block her. He just wanted her to have no part of those children. These things were all there. They were there. That he was.